If a family office hires a lawyer or a law firm, are all the communications with that attorney considered privileged? No. So all 50 states recognize the attorney-client privilege, but they all put limits on them. And they may differ at the edges, but what they have in common at the state and federal level is that attorney-client privilege exists when you have a communication between an attorney and a client, and the lawyer is acting in his or her capacity as a lawyer, and that communication is for legal advice. This comes up very often in government investigations, whether it's family members or trusts being investigated by the IRS or local tax authorities, or one family member suing another, and then the family office gets dragged into it, or trustees and family members having a dispute. But you need to remember those three things. It's a communication between a client and the attorney. The lawyer is acting in his capacity as a lawyer, and it's made to obtain legal advice. So we'll take those one at a time. So the communication is between the client and his attorney. So who is the client? If the family office hires outside counsel or hires the law firm, the family office is the client. So it could very well be that things that family members say to the attorney are not considered attorney-client privilege because they are not clients of the attorney or law firm, the family office is. So in cases like this, the best practice is to have each member of the family sign a separate engagement agreement with the law firm or attorney in their name so that each of them is also considered a client and they get the same protection with regard to attorney-client privilege. The other major caveat is that it's for legal advice. So if the attorney is providing business advice, financial advice, things like that, that is not legal advice and that is not considered privileged. And where this comes up very often is in very large family offices where you have people wearing multiple hats. And if you have an employee who is an attorney and he's performing some type of non-legal function, you are not entitled to attorney-client privilege with regard to that. So if the family office has a legal department and there's a lawyer there and he's providing legal advice to the family office 100%, that's great. But if you have him working in compliance, if you have him working in HR, if you have him working in accounts payable, accounts receivable, anything like that, if there are other people performing the same function and with the same title, job title, and they are non-lawyers, just because you put a lawyer there also doesn't mean that that lawyer gets any special treatment. Their communications would be able to be subpoenaed just like they would for the accountant, the HR person, and the CPA if they are doing the work of a CPA, an accountant, or an HR person. So again, best practices if the attorney or law firm hired is representing the family office and he's having extensive communications with any of the members, they should each have a separate engagement letter where they are considered clients in their own name with the attorney or his or her law firm. And as I said, think about what you're communicating with the lawyer about. If you're talking about non-legal issues, business, financial, things like that, if you're having personal conversations about family issues such as divorces, things like that, where you're talking to them more as a friend, that's a very slippery slope. And also consider the job role. So if you are hiring outside counsel, that's one thing. But if you have employees that work in the family office that have legal degrees and they are wearing multiple hats, or they're in a role where you have other people with the same job title who are non-attorneys, you're probably not going to get attorney-client privilege with regard to that when the IRS, when the SEC, when the DOJ, or disgruntled employees or other family members sue. So it's just something to think about because the time to think about these issues is before there's a problem. Once the investigators are there and lawsuits are filed and subpoenas issued, that's not a time to start trying to solve the problem. So anyway, my name is Pete, and I'm an attorney with 25 years of legal experience in the financial markets. I was formerly acting associate director at the Commodity Futures Trading Commission, and I drafted many of the hedge fund rules and family office rules. And if you'd like to work with me either as an attorney or on a consulting basis, my contact information is on this website. And because I am a lawyer, I will give you the disclaimer. Although I'm a lawyer, I'm not your lawyer, and nothing here is intended to be legal advice. It's for educational, informational purposes only and does not create an attorney-client relationship between you and I. I am a lawyer. I'm not your lawyer. Anything you do should be tailored to your own individual facts and circumstances and in discussion with your own attorney. And on that note, if you have any questions about this or any other videos I've done, just leave a comment below. And if you'd like to see future videos on a topic, just put that below as well. Have a great day, everyone.